Mr. Domina, good morning again.
Good morning, Your Honors. May it please the Court, I'm Dave Domina. I'm here on behalf of the County of Knox and 7 individuals who happen to serve as its Board of Supervisors that are before you as individual taxpayers. I'd like to start by recalling this Court's words in 1899, repeated in 1962, State v. Pointer. In every instance where this Court has spoken on the subject, it has determined that the legislature is powerless to relieve from the burdens of taxation the property of any individual or corporation, but that the constitutional rule of uniformity requires all taxable property to be assessed and taxes to be paid.
When those words were written, is it true that ad valorem property tax was the only form of taxation that we had in Nebraska?
It was. That was also true in 1962 when those words are repeated, Your Honor. We got the income tax, the sales tax, and a host of other taxes in the late 60s, as you know. In this case, what we're dealing with is not competition between a property tax and an excise tax, as the state urges, but between a property tax and a property tax. I'll get to that in a moment. But what's more important is this. In this case, the favored taxpayer completed construction and started the process of generating electricity in late 2008. So it was subject to property taxation in 2009. In 2009, the statute challenged here did not exist. So for tax year 2009, the property, the personal property constituting the wind farm, had to be equalized and made proportionate against all other personal property in Knox County. That was done. There is no complaint about that. The tax was validly levied, it was validly due, and now there is an attempt made to go to 2010 and grant a credit for what became validly due and payable in 2009 by creating a new universe against which to test uniformity and proportionality. That new universe is wind farms. It's not a wind farm against farm tractors and equipment and business equipment and the things that were subject to taxation in 2009. This is not a tax credit case, a conventional one. There is a parade of horribles in the brief suggesting that we won't be able to have income or sales tax credits. That's not true. Credits can be granted in current and prospective years. We just don't give tax credits for things that came due before. Under the logical extension of the state's argument, we should be able to equalize the tax burden of taxpayers who owed money under previous tax laws and those who owe it under current tax laws. This would be my income tax argument. I was around when Ronald Reagan was president and the marginal income tax rate was as high as 56 or 8 or 60%. Now under Barack Obama, it's only 38. I ought to get a break. Well, we tax by the year, and we equalize by the year, and we make proportionate by the year, and we don't do it by the enterprise. The problem here is not 2010 and forward. It's one sentence of section 776205, which says if you were a wind generator and you paid a uniform and proportionate tax on personal property in 2009, measuring against other uniform and proportionate property to be taxed, we're going to give you alone, not the owner of the tractor, not the business equipment, not the other taxpayers in 2009, you alone get a credit so you don't have to pay tax in the future. That's the evil here. It's manifestly a violation of the Constitution's commutation clause. I noted that the only other place in the state constitution that the word commutation is used is in connection with the governor's authority to commute criminal sentences. And I think the words commutation mean essentially the same thing in both places. Unless the governor is empowered to do it, he can't. The legislature is prohibited from doing it, and it can't. It also can't grant a special favor by going back to a closed tax year, selecting one taxpayer who happened to pay a uniform and proportionate tax on a uniformly and proportionately taxed kind of property and say, well, it looks like there's a new business here and we'd like to encourage it in the future, so we're going to give you a credit for the old years, so as you gather up at your industry conventions with your peers Nobody laughs at you because you went into business first.
Mr. Domina, if the one sentence that you described with the statute is unconstitutional, that is, if we were to agree with you, what does that do to the rest of the statute?
Leaves it intact. I don't think the rest of the statute has to suffer the constitutional infirmity of that sentence, because that sentence, codified as part of another section, Your Honor, is really a standalone provision. It alone creates the credit that is at issue here. I don't think you have to strike the rest, and I think the trial court's parsing of the statutory section was correct in that regard. Knox Countyans are the only persons who have a viable and vibrant interest in this because of the way the statute was written and because of the favored taxpayer. I think it's time to remind the legislature again of the limits of the Constitution. Thank you.
Thank you.